But governor will not do this. That's not his job. There's a sitting chief minister. It's an elected government.
You're right. At that stage, the governor is not really calling upon someone else to form government. But what he can certainly do is that, well, according to me, you have a ruling party with, say, which is supported in a coalition with, say, 60 members. Out of the 60, 40, which is a split. The governor says that, well, this is a split, and this is a split which is not recognized now by the 10th schedule. The speaker is going to take his own time to decide on the disqualification. But as the constitutional head of state, I do believe that with these 40, having, contrary to the constitution, moved away, at least as a head of the state, I require a trust vote on the floor of the Legislative Assembly. That I don't believe the governor would be wrong in calling for a trust vote.
I will say it is wrong, then I'll constitutionally provide an answer.
Why would that
The moment a governor does that, take Maharashtra, there are any number of parties apart from Shiv Sena, apart from NCP, apart from Congress. There are so many small parties. Now, those small parties at the moment supporting whoever is in power. The moment the governor does that, the buying and selling will start. In fact, the governor will be inviting, by his unilateral act of saying, prove your majority. There's no question of proving majority. He is the chief minister. Somebody else has to tell the governor that there is no majority. These are the signatures. These are the people who are with us. He doesn't have majority. If you allow that as a constitutional principle, it will be disastrous for democracy.
No, but the very fact that a disqualification notice has been issued initially to 16 and 22, this is not a case where the governor is sort of, finding facts, in the political spectrum. The governor is informed, the governor knows that, well, disqualification notices have been issued to 16 plus 22 or a group of persons.
Yes.
Which disqualification, the wrath of disqualification, the moment it attaches to a very sizable portion of the MLAs who are part of the ruling coalition, can the governor be said to be not justified in saying that, well, I'm not deciding the disqualification, but now please establish that you have a majority in the House, and I'll decide whether your majority depends on these 39 or your majority is safe irrespective of these 39.
Even otherwise on the arithmetic, the numbers are in favor of at that time, in favor of
because, Mr. Sibal, you are also right.
Independence of
Mr. Sibal, for the present purpose, because we still have to hear them on that aspect. Yeah. So as a hypothesis, we proceed on the basis that you are right, that these 39, they had really split. That too, a split is not recognized by the 10th schedule. Therefore, they necessarily have to go out.
Right.
Asking Mr. Eknath Shinde to form the government, that's a separate issue. We'll keep that aside for a moment. We'll have to hear them on that. But as an abstract constitutional principle for the governor, what else does he do?
Let's analyze the numbers now.
Does he say that
he still has the numbers? He still has the numbers. They are only 106. There are independents, there are other parties.
No, that point is, Sibal, that is again, because, can we say that then the governor is, you see, a lot of times what happens is the governor may have done something which is absolutely within his power, something which may run afoul of constitutional principles. But we have to we have to separate the grain from the chaff. Per se, when there is a disqualification notice moved to the speaker, in respect of a sizable group of MLAs belonging to the ruling party, how can we say that the governor is not justified in going to the government and say, come on now, prove your...
When does a governor, we'll have to go into that question then, when does a governor call for a floor test? Then we have to go into that question. Has ever a governor called for a floor test on his own when there is a government in power? Never. Never in the constitutional history of India. Never. The reason is simple. There is an elected government. He has proved his confidence on the floor of the House. There may be disqualification.
You see, because the defection has two consequences. At one level, the defection results in persons who have defected by virtue of a split ceasing to be members of the House.
Yeah.
But that very defection, which operates to exclude them from the membership of the House, also affects the legitimacy of the government, legitimacy in the sense, the strength of the government on the floor of the House. So, therefore, the very same act, which is unlawful, of a group of persons forming a split and going out of the party fold, they incur the wrath of
That
disqualification.
stage would have arisen if the disqualification petitions had been decided. Let's assume, Malad, that your lordship's example is right. But that stage will arise if the disqualification petitions are decided and they are out of the House.
No, but for that purpose, can the governor not say, well, I assume that they will be disqualified,
Well,
but
he
therefore
can't say that.
I need
Sorry,
I need a show of strength on the floor of the House.
But the governor has to wait on the constitutional process, the outcome of the constitutional process. Governor cannot say, I'll assume this or I'll assume that. Malad, I'm sorry. I mean, this is a proposition of constitutional law, Malad, with the greatest respect, that will ultimately encourage the kind of things that are happening today and we see all around. Please. Toppling of the government should be the priority as far as the governor is concerned.
Mr. Sibal, you are saying that constitutionally it's impermissible for the governor to take cognizance of any of those events which are all over.
Correct.
Nevertheless, he has no power to take cognizance of either the 10th schedule notices or even the earlier notices with respect to the speaker.
Correct.
Or even those representations of violation of the whip and all that has happened in the papers over.
Yes.
He cannot by himself take cognizance of anything like that at all.
Correct.
And ask the legislator or the chief minister to prove his strength in the floor of the House.
Correct. Because they are part of the Shiv Sena. They themselves say.
We are not on Shiv Sena. We are on the power of the governor.
That's right, even then.
Power.
Malaz, when an elected government is running, the constitutional principle, Malaz, I humbly submit is the following. If the numbers are stacked against the elected government for whatever reason, they can go to the governor and say, these are our numbers, these are how they are stacked. Governor, Malaz, verifies that issue, verifies the signatures. Normally, that's a practice that used to happen, but governors now say, we don't want to enter into the political thicket. But be that as it may, that may be a possibility then for the governor to say, look, I feel that you have lost majority because these people have come to us. But governor on his own can't do that. This is not no power of the governor to help in toppling an elected government. Whereas you assume governors will act constitutionally, but how many times have you struck down, Mulaz, actions of the governor who have acted unconstitutionally? And Mulaz, once that happens, Mulaz, then everybody else will get into the act, Mulaz, all those independents and all those people belonging to small parties. I don't want to say anything more. So Mulaz, please don't lay down a constitutional principle that will create havoc.
And Mr. Sibal, suppose in a given case,
Yes.
not in this case, the majority of the people in power, correct, we were part of the government, they along with the other party, correct, goes to the governor and says that, sir, correct, the present government, correct, has lost the confidence. We are the persons. Correct. In that case, the government
cannot.
Governor can. Why? Because governor has to set.
No, they are still in the party, Mulaz. They are still in the party. It is against paragraph 3.
All right.
Because paragraph 3 doesn't recognize majority minority.
Apropos what my learned brother said, and I remember when we were much younger, there would be that parade of MLAs before the governor.
Yes,
I don't see that now. That used to happen in the 1980s.
now it's not
and yes.
Because that's why, my lord, is the right question, but Mulaz, majority is now prohibited under 3. It
No,
doesn't
but
matter.
just taking the line of the reasoning which my learned brother put forth, could the governor not say that, well, I want you to demonstrate that you have your majority in the house. All right, I exclude 20 people who have in an 80-member house. I exclude the 20. I learn that there are disqualification petitions against 20 out of an 80-member house. Come before me or demonstrate to me that you still have 40 MLAs before you.
But we could have demonstrated and we would have won. If those 40 are, even if they are excluded.
So therefore, Mr. Sibal, the governor can, even you.
No, Mulaz, I don't agree with that proposition.
No, that the governor can certainly say that demonstrate to me that you have 40 out of 80 MLAs in an 80-member house.
It's nobody for the, it is not for the governor to say that. It's for those people in the house to go to the governor and say they have lost majority. It's not for the governor to enter into the
Fair enough.
ticket.
But suppose those people, therefore, obviously the opposition in the house would say, well, they have lost their 40. In which case, what does the governor do? At a primary level, the governor says, well, now I have learned from the opposition that you cease to have 40 out of 80, which you had originally, or say 45 out of 80, because 20 I have now been issued disqualification notices, so that your strength comes from 45 to 25. Now, please, prima facie demonstrate to me that you still have
Okay,
40.
Let me try and answer that.
How does the governor then
let me
proceed? What
try
does
and
the
answer.
governor do in a situation
Let
like
me try and answer that. Mullad's governor prima facie on the arithmetic of the house must first come to the conclusion that the leader of the house has lost the confidence of the house.
Absolutely correct.
How will he decide that? If somebody goes to him. Somebody goes to him and says, this chief minister has lost the majority, lost the confidence of the house because
Now,
these are the numbers.
Two sets of people could go. Either the opposition would go, or even the defecting MLAs would go. I mean,
No,
they have.
No, they can't.
Why? They will say that, well,
We don't support this government.
Hypothetical examples ultimately, when and if it comes to your lordships, because we are not dealing with that situation. We are dealing with a person who has been recognized by the governor, who happens to be part of the 39 and who has given oath of office. We are only dealing with that issue. As and when that issue and some hypothetical stage comes in, we can debate that constitutional issue. But why?
but it's not hypothetical here at all. It's a live issue here. For the reason that once the governor is in possession of facts which indicate that a very substantial.
Which is the fact that indicates that he has lost the majority of the
that
house.
there were that out of 55,
Yes.
out of 55 MLAs, 38 there are disqualification notices issued
So-
by the ruling coalition
15
itself.
plus 50, 53 plus